In Minnick v. Mississippi in 1990, the Supreme Court of the state of Mississippi had ruled that the Miranda decision requires that police allow a suspect to confer with a lawyer only once, and that the police are free thereafter to interrogate the suspect in the absence of the suspect's attorney. The United States Supreme Court reversed the state court's ruling, holding that once a person in custody requests an attorney, police may not initiate further questioning until the attorney is present. In Arizona v. Fullamante, 1991, the Rehnquist Court ruled 5-4 that coerced confessions may sometimes be used as evidence in criminal trials without necessarily invalidating a conviction. The admission at trial of coerced confessions may be excused as harmless error if it can be shown that other evidence obtained independently of the confession is adequate to support a guilty verdict. In 1968, the United States Congress passed legislation intended to narrow the scope of the Miranda decision. The law provided that only coerced confessions could be excluded at trial, but that voluntary statements made without police warnings were not to be excluded. The law went untested for 30 years. In 1997, Thomas Dickerson was indicted for bank robbery. Before his trial in 1999, Dickerson had asked a U.S. District Court judge to suppress a statement he had made voluntarily to FBI agents on the grounds that he had not first received Miranda warnings. The District Court granted the motion, but the Court of Appeals reversed, ruling that under the 1968 law, Dickerson's statements could be admitted as evidence. The United States Supreme Court struck down the 1968 law in Dickerson v. the United States 2000 as unconstitutional, holding that Congress cannot modify a Supreme Court decision, in this case the Miranda decision, by ordinary legislative enactment.